Hello, welcome to Lovers. We have seen the natural justice principles, their explanations, and the landmark case laws, right? So now we are going to see the exemptions. Exemptions means what? In what all situations natural justice principles are not followed or need not be followed. In some of the situations, it need not be followed. What are they? In today's video, we are going to see that. So, the exemptions of principle of natural justice and administrative law. So, what is that? Normally, an administrative authority, while exercising its powers, follow natural justice principle. Okay, you have seen for everything, administrative authority is following natural justice principle for the decision making or for any fair trial, everything, right? So, but in some situations, it is not followed. And what are the situations we are going to see? So here in some of the cases, it can act without following natural justice principle and nothing unfair can be inferred by not giving an opportunity to present the case. Okay, the first exclusion is statutory exclusion. When the legislatures may enact law that expressly exclude or modify the application of natural justice principle for certain administrative actions. These statutory exclusions provide legal clarity and may be deemed necessary to achieve specific policy objectives or streamline decision-making process. When the legislatures are making laws and enacting laws, here for the exclusions of natural justice principle, they may exclude or they will modify some of the laws. Then the exclusions comes up here so that here nothing unfair can be inferred when the natural justice principle is excluded. Okay, so when some statutory exclusions are provided, it has to be subjected to judicial review. And if the why judicial review is done is to prevent abuse or arbitrary exercise of power by authorities. Okay, so that when authorities make something, if it is not proper, they are subject to judicial review. So here you are seeing is that any action of the parliament which does not permit the individual certain right during the time period. You are seeing that during the time period. This is very important. The time period is for some time. The natural justice is not followed. Okay, such act is bound to come under scrutiny of the courts and may be challenged under Article 14 of the Constitution when some rights is denied for some particular period of time only. Then it can be challenged under Article 14. But when the a statute may exclude natural justice either expressly or by necessary implication. Well, here the doctrine of necessity was applied. Karan Lal Sahu versus Union of India, that is also known as Bhopal gas disaster case. The second one is legislative function. So what is legislative function? Legislative function is usually an order of general nature. It is normally for as a whole. It's not for a person, just for a whole of person and not applying to one or a few specialized person is regarded as legislative in nature. Okay, it has to be of general nature. Is legislative action, plenary or subordinate, is not subject to rules of natural justice because these rules lay down a policy without reference to a particular individual. So, when if a legislative action is done by the government, whether it is a plenary or subordinate, it is a whole class. It is not for one person. For example, I've given farmers. That is like farmers when a grant is provided for farmer, it is not given to one person. It is for whole farmers who all are eligible. They can apply for that, and who would require the grant or any sort of things can approach the authority. This is a simple example of this legislative action. In legislative action also, Bhopal gas case comes in wherein Supreme Court held that oh legislations by Parliament, no principle of natural justice is attracted. Okay, provided such legislation is within the competence of legislature. So what is legislature action is for a whole class. It is not for one person. So here the Bhopal gas case can be an example. Provision of the Constitution. The third exclusion of natural justice is provision of the Constitution. In provision of the Constitution also some exclusions are provided. So in what all provisions you can see is that what all articles it is excluded is that Article 22, Article 31 Clause A, Article 31 Clause B, Article 31 Clause C and Article 3011, Article 311 Clause 2. They are the situations in which constitutional provisions exclude and it may if the legislature exclusion is arbitrary, unreasonable, and unfair, court may quash such provisions under Article 14 and Article 21 of the Constitution. The next point, emergency, the fourth one. In an emergency situation, natural justice can be excluded. In India, in cases of emergency or urgent situations such as during public health crisis or in matters of public safety, the application of natural justice may be postponed or adjusted to respond to the immediate situation. So where the situation is in where the situation is very much in emergency, such as health issues, health crisis, matters of public safety. In such situations, natural justice can be avoided. You can see in Corona time, people were not allowed to move, right? The movement was curtailed, right? Thus, you were in quarantine. You cannot say that I want to go out. That's my right. So this is an emergency situation that public health situation is affected. You have to be at your house or wherever you are in quarantine, right? Hope you are all seeing that situation. So it is very familiar to you. That is one kind of emergency which we all faced. So this is another situation and health crisis. When emergency situations comes up, natural justice will not be followed. A case in emergency is that state of UP versus Jabal Singh. The Supreme Court of India held that in an emergency situation such as an immediate threat to public safety, the strict observance of the rule of natural justice might be relaxed. In such cases, the need to act promptly could outweigh the necessity of giving a fair hearing. Now, you cannot say that you have to be heard and the decision has to be taken. When the situation of emergency comes up, the situation of public health comes up, it, any kind of natural justice will not be observed. Okay. This is another case is that Mohinder Singh Gill versus Election Commission. The constituency elections were going on in Firozpur city and it was interrupted by mob violence, which caused some ballot papers and boxes to be destroyed while the elections were still underway in some places. So the election was going on in some places, but mob, due to the mob activities, some kind of violence, mob violence, some of the ballot papers were destroyed, and the Election Commission of India ignored the right to be heard and without any notice ordered re-election. Since ballot papers were destroyed and violence occurred in that place, Election Commission of India ordered a re-election. The court did not interrupt the work of Election Commission of India and dismissed the claims by notice by saying that this was necessary in an emergency situation and audio alter pattern can be ignored in this situation. And some people approach court that Ore alter partum was not followed, as natural justice was not followed. People were not given opportunity to say the part. So the court said that here any kind of natural justice need not be followed, any kind of Ore alter partum need not be followed since it was in an emergency situation and there is no need to follow an natural justice principle here. The fifth exclusion is impracticality. What is that? Natural justice can be followed and applied when it is practicable to do so, but in some situations when it is impracticable to apply the principle of natural justice, then it can be excluded. As simple as that. When it is not practicable to observe natural justice, it can be excluded. This is impracticability. In Bihar School Examination Board versus Subhash Chandra. What was the case? This is also known as mass popping case. Okay, the Supreme Court held that the ground of impracticability hearing can be excluded as conducting hearing is impossible when there is thousands of students involved. So the Supreme Court held that on the ground of impracticability, hearing can be excluded. This was the main theme of the case. You can see the facts. The board conducted final 10th standard examination. Okay, this was a scenario at the particular center, and there was thousands of students appearing for the exam, and there was mass copying going on, and mass copying was alleged. And in the evaluation also, it was seen that mass copying as the most of the answers were similar and received same mark. If persons also receive the same mark, the answers were also similar. So it is concluded that mass copying has occurred. Okay. For this reason, the board cancelled the exam without giving any opportunity of hearing and ordered for fresh examination, whereby all students were directed to appear for the same. So the board didn't go for any kind of hearing or anything, just declared a re-examination and all students were directed to appear for the exam. Many of the students approached the Patna High Court challenging that on the ground before cancellation of exam, no opportunity was given to them and the High Court, Patna High Court, struck down the decision of the board in violation of Ore Altum Partum. And when it went to the Supreme Court rejected the High Court judgment and held that in this situation conducting hearing is impossible as thousand notices has to be issued to everyone and the opportunity of hearing also has to be given to everyone. Cross examination has to be conducted, rebuttal has to be done, presenting evidences, everything has to be done for a mass of personalities, which is very, very difficult and is not at all practicable. So the Supreme Court held that the ground of impracticability hearing can be excluded. So here no hearing was given to them and no natural justice principle was followed. So this is a case in impracticability. So other exemptions, there are some other exemptions also other than this. What are they? In cases where authority involved is academic in nature or if the authority is of complete administrative nature. In such cases, their evaluation may be excluded from the ambit of rule of natural justice. In the case Jawaharlal Nehru University versus P.S. Narwal, respondent was a student of Jawaharlal Nehru University. The student was removed from the university on the basis of his academic performance without being given any hearing. The hearing was not given and notice also. And the case reached the Supreme Court. The court observed that nature of decision is academic in nature. And whether the court has to interfere is that the decision from such authority automatically declines any right to be heard. Academic evaluation is done. No other authority is responsible for that. And it was held that if the assessment of the authority is competent and it decides that the work of the particular student is unsatisfactory, then the rule of natural justice may not be applied. And here the rule was not applied and the person was not given a hearing. The second one, another exemption is interdisciplinary action. Interdisciplinary action like suspension, etc. There is no requirement to follow the principle of natural justice. In the case S.A. Khan versus Haryana, state of Haryana, the Supreme Court held that suspensions being interim disciplinary action. There is no requirement to afford hearing. When a person, if you're, for example, when some activities are occurring in your campus, some fight has occurred between two persons or a gang of persons for disciplinary action, when a principal suspends some persons, it is interdisciplinary action and there is no requirement for any hearing. So this is an example. Okay. The third other exemptions are useless formality theory. That is where the facts are admitted or there is no dispute, that is undisputed. You don't have any dispute. The facts speak for itself. Okay. This is useless formality theory. It can only be used where on the admitted or undisputed facts, only one conclusion is possible, and under the law, only one penalty is permissible. So, one conclusion and one penalty, there are no inferences other than the things seen. There, this useless formality theory can be applied. It should be used with great caution by the court, otherwise, it would turn out to be real of miscarriage of justice. Court, while using this theory, has to be very careful because uh, to see any miscarriage of justice has not occurred. So it is rarely used theory. Okay. In a case, a very big name, don't get with a very important case also. You can see Dharma Ratnakara, Rai Badur, Arcot, Ramaswamy, Mudaliar Education Institute versus Education Applied Tribunal. Okay, one lecturer, she was given leave for going for MPhil, but she went for PhD. And when notice was served to her, she admitted that she had joined PhD course and her service was terminated. And when she approached the private education institutions, Karnataka Private Education Institution, and the High Court, the termination was invalid. But the Supreme Court held that opportunity to show cause was not necessary where facts were undisputed and the affected person could not put any valid defense. Here you can see she accepted that she has gone for PhD. She had to go for MPhil, but she went for PhD. And when the when this was alleged against her, she admitted the fact that she has gone for PhD. And here, the Supreme Court said that there was no opportunity has to show cause has to be given because she has admitted the fact. That's just empty formality, right? The fourth one in other exemption is confidentiality. Exclusion of natural justice can also take place when confidentiality is demanded and is necessary to be maintained. When the thing has to be confidential, then the natural justice principle need not be followed. So in Malik Singh versus State of Punjab and Haryana, you can see that the Supreme Court held that maintenance of surveillance register by the police is a confidential document and neither the person whose name is entered in the register nor any other member of the public has access to it. The surveillance registers maintained in the police station. It has to be confident document. It is not for public purpose, and public cannot have access to it. Only the members will have access to it. Okay. The court also observed that surveillance is for that, since if other than the person authorized, if they have access to that, the public have access to the surveillance camera, then the justice will not be proper. it can have miscarriage. It can defeat the very purpose of surveillance. The secrecy, the confidentiality will not be followed. So here the natural justice need not be followed. Okay. The next exclusion you can see is government decision, government policy decision. In a case Balco Employees Union versus Union of India, that is 2002 case, here the Supreme Court was of the view that in taking a policy decision in economic matter in length, the principle of natural justice has no role to play. So, in the last one, and other exemptions, government policy decision. Here we can see Barco Employees Union versus Union of India. There is 2002 case, and we can see the Supreme Court was of the view that taking of a policy decision in economic matters in length, the principle of natural justice have no role to play. So, in principle of policy decisions in economic matters, here the natural justice has no role to play. So, this is the exemptions which I have seen in natural justice. So this is exclusions of natural justice. Hope you got a fair and good idea about it. And thank you so much. We'll see you at the next video. Please subscribe to my channel and please put on your valuable comments. Thank you so much.